Hello, welcome everyone. Thank you for joining us for today's webinar. My name is Janvi Shirsat and I will be your host today. So, today we are presenting an international webinar on force majeure in times of COVID-19 with the keynote speaker Dr. Astha Mehta ma'am. So, just a little housekeeping before we get started. So, if you have any questions during the webinar, please type it in the chat box. We will bring them up after ma'am finishes her presentation. So, before introducing our esteemed speaker, I would like to enlighten the listeners about LicitElite. LicitElite focuses on providing assistance to law students in self grooming while acquiring better knowledge by generating an exclusive learning platform through activities like law classes, blog writings, competitions, etc. It also aims to connect with legal experts to design better learning opportunities. So now, without further ado, we will turn the time over to our keynote speaker, Dr. Astha Mehta. I feel honored to welcome ma'am for this session. So, Dr. Astha Mehta has secured her BA LLB honors from Nalsar University of Law, Hyderabad. Subsequently, she pursued her LLM in business law from Amity Institute of Advanced Legal Studies, where she was awarded a gold medal. She has completed her doctorate in the area of limited liability partnerships, wherein she has done a comparative analysis between India and Singapore. She has an experience of 7 years in academics and 2 years in corporate and litigation. Apart from specializing in designing innovative curriculum from accommodates multiple intelligence and reaches all learning styles, she is deeply involved in facilitating internships and recruitments for students across prestigious law firms and MNCs in country. She is also the founder of Arbitration and Mediation Skills Center AMSC and is in charge of international collaborations and outreach too. So she is also the center head of Harvard Business School online HBSO courses at Sushant University. And yeah, I think thank you so much, ma'am, for joining us today. And without further ado, I guess we can just begin.
Thank you so much, Janvi, for such a lovely introduction. Good morning, everybody. I would begin by thanking Mr. Param Bhamra and LicitElite for inviting me as a speaker for the webinar today. And I hope that all of you and your families are doing well. Well, COVID-19 has drastically changed everything around us and has, especially in 2020, brought life to a near standstill. And it's almost been 2 years, and we are still wondering as to when normalcy will be restored and we would no longer be living under the fear of COVID-19. As the contact with people, it exacerbates the transmission of virus, and eventually things anyway have to open up. So definitely there is a new normal, and looking at the brighter side, we do have a world that is better prepared, that's safe and healthier. But people do let the guards off when things are a bit better and then another wave hits the country. So these pandemics can definitely reignite if we don't follow social distancing norms as new normal, and it would take a lot of time to tackle the situation. So social distancing have to be maintained even after things get okay, and we need to learn from countries like Japan, where social distancing has always been a norm, and this is the reason for lesser number of COVID cases also over there. So today our discussion is going to center around force measure in the times of COVID-19. Now, the onset of COVID-19, the pandemic in India, also proved to be an economic crisis at an unprecedented scale. So there were restrictions on movement of people, on movement of goods, unless somebody is involved in providing services related to essentials. Now, there were serious questions raised on the ability of parties to perform their obligations under contracts when, these are not ordinarily qualified as essential services. So what do you do in those cases? So there was a lot of uncertainty as to the performance of contracts, that led to parties envisaging breaches of contract and assessing their rights and remedies in relation to the same. Now, moving further, if we look at force measure and risk measure, I'm sure all of you have heard of these terms. Now, when we look at force measure, it means an event or effect that, that can be neither anticipated, you can't even control it. So it includes, both your acts of nature and your acts of people. So if we are saying it includes acts of nature, then definitely it is including act of God, that is vis major. So force measure basically is a wider term than vis major, so it covers it. And just that force measure is covering your natural and artificial unforeseen events. Whereas if you're talking about act of God, vis major, that's only covering your natural unforeseen events. Now, in a lot of cases, if we look at the effect of both the terms, whether it's force measure or whether it's vis major, basically it's going to just, excuse your non-performance of a party, and then it's going to, prevent a party from being liable for breach of contract. And it's going to save the non-performing party from consequences of something over which, they have absolutely no control over. So there are force measure clauses in contracts, and there are times when the force measure clause is missing from the contract. So whenever, the force measure clause is there in the contract, that is negotiated between the parties, and it specifies the events which are going to fall under or which are going to qualify as force measure events. For example, your act of God, riots, labor strikes, or act of government, pandemic, boycotts, quarantines. So let's say if the word pandemic is specifically mentioned in the force measure clause and the event occurs, then the affected party may be relieved from performance, right? Now let's talk about the scenario where such an event is probably not mentioned in the force measure clause. So many force measure clauses would would be phrased in such a way that in addition to your specifically mentioned event, maybe it says that including but not limited to, or any cause or event outside the control of the reasonable parties, outside the reasonable control of the parties. Now where your clause is phrased in such a manner where even if the word pandemic is not mentioned, but you can definitely apply your interpretation principles, and then apply a jusdem generis, and then you can argue that epidemic or pandemic like COVID-19 will fall within the ambit of force measure clause. Now even otherwise, where let's say you don't have a force measure clause which is structured in such a way, then if your act of God has been specifically included as a force measure event, it can be contended definitely that pandemic like COVID-19 is an act of God. So we don't have any case law as such, but it can definitely be argued like that. Now, if you look at Indian courts, they have not directly ruled that a pandemic like COVID-19 is an act of God, but definitely you can, argue to that effect, and you can derive support from certain decisions of the Supreme Court where they have said that, the expression like act of God, it basically signifies the operation of natural forces, which is free from human intervention, with the caveat that, every unexpected natural event does not operate as an excuse from liability if you have a reasonable possibility, of anticipating their happening. So, similar judgments have also been passed by various high courts as well. However, if we, uh, excuse me, so however, if we're going to look at the courts in the US and UK, they have specifically held that, your expression act of God is going to include a pandemic and an epidemic, whereas that's not the case in India. So, but if we look at the statutory provisions, let's say that force measure clause is not there in the contract at all, then we can definitely attract provisions from the Indian Contract Act of 1872, which would be relevant to force measure. Like if we talk about Section 32 of the Indian Contract Act, which basically talks about your contingent contracts, which are depending on, happening or non-happening of a future event. And then this future event becomes impossible, then the contract becomes void. Now, if we are attracting Section 32, then your performance or under the contract, the obligations that you have taken under the contract should be something that you have spoken about. Your contract is dependent on that. Then definitely you can take shelter under Section 32. But otherwise, if it is not an event which which is probably outside the contract, then in that case we do have Section 56 where you can take shelter under. And Section 56 basically talks about your frustration of contract because of some subsequent event happening, rendering it void, where it becomes completely impossible for you to perform your obligations under the contract which you've undertaken. Now, even if we talk about the obligations that you have taken under the contract, now doctrine of frustration or your supervening impossibility can only be attracted in case where there is destruction of subject matter, where the subject matter does not exist anymore. And if the subject matter doesn't exist anymore and the destruction was beyond as in both the parties are not responsible for the destruction, it's beyond their control, then you can both the parties will be excused from performance of the contract. And there's failure of ultimate purpose, or there is death or personal incapacity of the promisor, or there is a change in law, or there is outbreak of war. Today I enter into a contract with somebody where I say that I would be supplying you certain goods by the end of this month, by the end of February, and you would have to make this much amount of payment, and it has been agreed with free consent by both the parties, and all the essentials of the contract have been satisfied. Then in that case, what if before I could actually make the delivery to you, the goods that I have promised to deliver, let's say the government has banned private trading in those goods, or there is some let's say something found in those goods which the government has banned that particular ingredient, then I would not be in a position to supply those goods to you at the end of the month. So if there is a change in law or the government has taken some decision, then definitely I cannot go against that and still go ahead and supply the goods to you. So definitely I will not have to perform the contract. I'll be excused from performance and the contract would be discharged. Similarly, if there is an outbreak of war, definitely you cannot go ahead and perform the contract. You will be discharged from performing your obligations under the contract. But there are certain cases where it's not going to be applicable, where you're saying it's merely difficult for you to perform the contract. There's commercial impossibility. Probably there's something happening in the country where right now the transportation available to you to supply the goods is available at a very high cost. So that's not going to excuse you from the performance. There, the doctrine of frustration or the doctrine of supervening impossibility is not going to be applicable. So if you have strikes, if you have lockout, that's also not going to be a reason where this doctrine is going to be applicable. If one of the objects have failed and you had 3 to 4 objects while entering into the contract, then you'll only be, if you can divide those objects separately, they have nothing to do with each other, then you'll have to go ahead with the contract, perform your part of the contract, and probably your performance with respect to that particular object would be, excused. Now, since we were talking about, section 32 and section 56, now, like I said, section 32 would be applicable where, that event has already been spoken about in the contract, where it is within the purview of the contract, and section 56 would be applicable where it is outside the contract. Also, this has been made very much clear by a landmark judgment of Satyabrata Ghosh versus Mugniram Bangur. Then definitely with, each case coming to light, specifically in the last 2 years, these cases can, throw some interesting issues. So, where the contract contains the force majeure clause, but, defines the force majeure events in a restrictive manner. Let's say, it does not specifically mention either pandemic or epidemic or act of God, and also does not contain such language which says, where you can actually apply the uh, rules of interpretation and you can put ad jusum generis to use and include the similar. There you can argue that section 56 can be applied to, excuse performance, since the epidemic or pandemic is not relatable to the force majeure clause in the contract. So you would definitely have to prove here that it was completely impossible for you to fulfill the contract. And it was not merely inconvenient, or it was causing certain financial obligation on you to perform the promise that you've made under the contract. So you'll have to, go ahead and prove it to such an extent that it was completely impossible for you to go ahead and fulfill the contract. That is the reason you should be, excused from performance. So, even if a pandemic like COVID-19, it falls within the ambit of force majeure clause, that by itself is not going to relieve a party from performance of contractual obligations. So what I was trying to basically say was that the force majeure event should actually have a direct impact on the non-performance, and the party which is, seeking to rely on the force majeure event is also under the duty to mitigate or to, explore alternate means of performance. So we all, we have heard under the contract that you have the duty to mitigate the losses. For example, if you are, telling somebody to, if the employer is firing the employee and not allowing them to serve 1 month notice period, which is mentioned under the contract, then in that case, you would have to give them like a month's salary as mentioned in the contract, or you would, let them serve 1 month notice period. Now, if you're saying that, we are going to pay you a salary, or we're going to let you work till the time you find another job. So there it has to be a reasonable time period. Just because somebody is telling you that, that doesn't mean that for 6 months or for a year, you're not going to look for another job, or you're going to let the opportunities go. There, the courts apply the duty to mitigate the losses, and they say that you would only be entitled to a compensation of 1 month, which is a reasonable time period. So this is how it works out. And if we go back to the first nationwide lockdown, which happened in 2020, where, only essential services were allowed and nothing else was allowed. So there, if such a thing ever happens again, you would not be able to fulfill the contract if it relates to non-essential services. So there, the parties would have to be excused from performance, because nobody actually saw that, something like COVID-19 would come, and people had entered into so many contracts. And when there was a nationwide lockdown, people found it extremely, difficult. It was completely impossible for them to go ahead and fulfill the contract till the time, the restrictions were eased a bit. So it could be that, performance of a contract may or may not be affected by COVID-19, is where, there were a lot of cases where the employees of an organization, they, had COVID and they had to isolate themselves at home, and they were not able to come to work. So In case, it's a nature of work where you can work from home, then definitely you will not be excused from performance. But if it's a nature of work where you have to come to the in specifically in the service industry, if you have to come to office and then only the work can be done, then definitely the performance can be excused in such a case. But otherwise, saying that a person has to isolate himself or herself at home, and this is the reason they cannot fulfill their obligation under the contract, you cannot take that excuse unless it's actually the reason. If there is no impact of that on delivery of services, then definitely this excuse would not be available. So any non-performance, due to an economic downturn or other general, business conditions resulting from COVID-19 or from the pandemic, are not likely to be, sufficient to seek excuse from performance of a contract on the ground of force majeure. Now, the force majeure clause, it may require parties to take reasonable efforts to, perform the contract by alternate means. So, even in the absence of an express provision, any party which is, wanting to rely on a force majeure event to excuse its non-performance and say that, I'm completely not in a position to fulfill the contract or fulfill my obligation under the contract, they will have to demonstrate that they were unable to perform their part of the obligations that they had undertaken under the contract, and they have taken all steps to mitigate the effect of the force majeure event, and still they are not in a position to fulfill the obligations. So where you can prove that, definitely you can take rescue the same. uh, So basically, I'll just conclude and just put it in a simplified manner. So even if you don't, one is that, you have a force majeure clause, then you can definitely, take that force majeure clause into account and say that the word pandemic has been mentioned. So I should be excused from non performance. But there also, you would be excused from non performance in case there is complete impossibility. Second case where, the clause, the force majeure clause is there in the contract, but it doesn't mention the term pandemic, or it's structured in such a way that, it says that you can include the similar. There definitely, you can apply the principle of interpretation principle of ad justum generis and cover other things as well. So the pandemic would be COVID-19, or the word pandemic would definitely be covered. Now, there can be a scenario where, the word um, pandemic, or let's say the force majeure clause is completely missing from the contract. There definitely you can take rescue of the two sections under the Indian Contract Act. One is Section 32 and one is Section 54. Now, irrespective of whether there is a force majeure clause or there is no force majeure clause in the contract, you would definitely have to show that, whatever obligations that you have undertaken at the time of entering into the contract, you cannot fulfill them. It's become completely impossible. So just saying that there is difficulty in performance, there is a difference. So if there's difficulty in performance, then definitely you would not be excused. So the only relief is that, whether you have a force majeure clause or you don't have a force majeure clause, you can still, rely on provisions under the Indian Contract Act, and you can excuse yourself from non-performance. And in either of the cases, you have to show that, that you're not in a position to perform your part of the contract. So that's the simple, that's the more, that's basically the current position as well. So we can take up the questions if any one of you have the same. And one last thing I would like to mention here. A lot of us were reading in the newspapers that, those who have taken up the properties in rent, they don't have to pay the rent. So certain advisories were issued by certain state governments in the first lockdown, that the tenants should not be forced to pay the rent, since it's become very difficult for them to do the same. A lot of people had to shut down their businesses, and a lot of people had to were out of work, they were not getting their salaries. But nothing like that happened in the subsequent lockdowns. So we don't have a law as such where you can say that the owner cannot evict the tenant if in case he's unable to pay the rent. So there's nothing like that. So any questions?
Listeners, kindly drop your questions in the chat box. Ma'am, just a minute. We'll just check out the questions and I'll just tell if there are any questions or not. Ma'am, I guess there are no questions from the audience. So thank you so much, ma'am, for such a vibrant, interactive, and knowledgeable session. I would also like to thank all the participants for joining us and would request everyone to fill the feedback form before you leave in order to receive your certificates. Thank you everyone for joining us. Uh, yeah, at the end, I would like to make an announcement. LicitElite is hosting its first international moot court from 25th to 27th February 2022. So we'll be sending all the details in the chat box and in the email with your certificates. Spots are filling fast and receive your spot right now. Also, if you don't want to miss any updates, follow us on our social media handle and also join our WhatsApp updates group. Then stay healthy, stay safe. See you all soon. Thank you so much, ma'am.
Thank you so much, Janvi, and thank you so much, Param and LicitElite. And thank you so much, everybody who was attending the webinar.